It's my honor and privilege to invite Dr. Justice CJI Chandrachud, Honorable the Chief Justice of India, to deliver the inaugural address.
Namaskar and good morning. Sister Justice B.V. Nagaratna, Chairperson of the Juvenile Justice Committee, Ms. Annapurna Devi, Minister for Women and Child Development, my distinguished colleagues in the Supreme Court, Chief Justices and Judges of the High Court, present here from all over the country, Ms. Cynthia McCaffrey, Country Representative of UNICEF India, Mr. Gopal Mitra, the UNICEF Global Lead on Disability, distinguished guests, and all those dedicated to the protection and well-being of our children. It's really a signal honor for me to participate in the inaugural session of the 9th round of the National Annual Stakeholders Consultation on Child Protection. I would like to express my sincere gratitude to all the esteemed judges, secretaries from various ministries and departments, members of the law enforcement agencies, legal services authorities, commissioners for persons with disabilities, representatives of training institutes, law universities, and UNICEF for your tireless commitment and invaluable contributions to this year's juvenile justice consultations across the states. This year's theme holds a special place in my heart: the protection and well-being of children with disabilities. As someone who, together with my wife, Kalpana, who fosters two young, wonderful daughters, I am reminded daily of the joy, purpose, and love they bring into my life. They have transformed not only how I see the world, but how also I engage with it, strengthening my commitment to creating a more inclusive society where every child, regardless of their abilities, is cherished and protected. Our children suffer from a condition. They have been born with a condition called Nemollin myopathy. It's a genetic condition which they have inherited at birth. They were born in Uttarakhand. Before they came into our lives around 2014, there was an absence of knowledge about myopathy. Absence of knowledge among doctors, among caregivers, and certainly complete absence of knowledge on the part of their parents. And of course, everyone lives, in a sense, in a feeling of self-denial. The families where the children are born feel that, well, there's nothing wrong with them. There were no testing facilities, even in major institutes in India. And where there were testing facilities, such as the Postgraduate Institute in Lucknow, we were told that the test then was so invasive and so painful that they would remove a part of the tissue from the child without anesthesia. It was so terribly painful. And I still remember the time when the test was done. The test had to be done for both the children. And after the older child underwent the test, all that she could say in that sense of pain and suffering for the test, she says, "Don't allow my sister to go through this, please." So there was an absence of adequate testing, absence of schools in Uttarakhand. When the children came to us in Allahabad, the sole school, which was run by the good Mr. Banerjee for children with disabilities, had shut down because Mr. Banerjee was no more. And there was no school where the children could even learn the basics of alphabet or everything that a little child aspires for. But the children would always have little school bags at home with a snack box and their bottle of water, because that represented their feelings. They aspired to go to school. So they would play school with their own little bags at home. But when we moved to Delhi, we found a school for them, which was Tamanna, run by the redoubtable Dr. Chona. And she said that, this is not a school for these children. This is a school for children suffering from predominantly autism. These children are fine because they have a genetic condition, but they are mentally as razor sharp as any other child. And gradually, she said, we have to mainstream these children, which is what we did. Now, we were thinking of sending them to a good school. So we went to various schools, and the first question that we asked was, how will the other children treat these children in school? And does the school have any sense of policy to ensure that these children are not bullied, that these children are not disparaged, because that would really set them back? And the principals of so many schools told us that, well, children are children, so they'll have to survive amongst other children. Until we found Sanskriti, and they said that we have mentor children, we have friends who will be associated with these children to ensure that other children learn how to deal with them. Another problem which so many of these children with disability face in school is that when you mainstream these children, because they are capable of being mainstreamed, you realize that there are very few facilities to accommodate the real needs of children. So if a child is fond of science and the science lab is in a basement, the child can't go to the science lab for the simple reason that there is no ramp and there is no lift. So a child has to sit in class when everybody else goes to a science lab, though science is so close to that child's heart. Or when all the other children go to the playground, that child can't go to the playground because once you're out, it takes such a Herculean effort to come back to class. All of the children participate in dramatics. All of the children participate in poetry or debates. But children who have a speech defect, as all children with muscular disorders do, they are not allowed to participate in dramatics because of the fear that the audience may not have the patience or the tolerance to give that child another 2 minutes to explain what that child has to say. So these are some of the problems which good institutions face even today in capital cities like Delhi. What about gene therapy? Gene therapy is really at the cutting edge of knowledge today. I was at a conference on gene therapy in Bangalore last weekend, again for a reason very close to my heart. Now, gene therapy costs between 7 crores to 30 crores for one single dose today. Who can afford it? But there is reason for hope because countries like India are now taking steps forward to provide for accessible medicine and accessible treatment. But that has to be part of a national policy, guided and supported by the government. Policies cannot be only for the mainstream, because these children are capable of the very best. Because they have minds of their own, they have individualities of their own, they have a volition of their own. I still remember that during COVID times, I hope I'm not taking too much of your time and I'll keep to my time and cut short my written text. During COVID times when schools were online, our little Mahi, who was then just about 9, suddenly heard the noise of a woodcutter, an electric woodcutter. And she tells the teacher, can I please break from the class for a minute because I think someone is cutting a tree in our garden. So the teacher says, yes, of course you can leave the class for a couple of minutes, but be sure to be back. So she goes into the garden and of course, lo and behold, you have the horticulture department trying to prune the trees as they normally do to make them look more attractive. And she runs into them on a wheelchair and says, you dare not touch any of these trees because these trees are homes, they are nests, and they are the homes for our birds who come here. And if you cut these trees, the birds will have no place to survive. What I want to emphasize is that there is a great deal of transformative potential in children suffering from disabilities. They are not just children who are in need of care and protection, but they have within themselves the ability to transform others. As my contact, not only with Priyanka and Mahi, but with other people suffering from disabilities who've I've been able to interact with, who've transformed our lives and our institution. And I'll give you a few examples just in a moment. Mahi, in particular, is a fierce environmentalist, and she believes in following a cruelty-free lifestyle. She's mother to 8 cats, and she single-handedly delivered a litter of 5 when her favorite cat gave birth to a 5-litter kitten just about 2 months ago in the middle of the night. But she, in the course of following a cruelty-free lifestyle, had been telling us for the last 10 years that please adopt a cruelty-free lifestyle. It took 10 years for me to be persuaded. Judges sometimes take a very long time to be persuaded, including in the court at home. But they were the reason why I switched to veganism. Because veganism is not just about being a vegetarian and excluding dairy and honey from your diet. It's also about following a lifestyle which does not accept cruelty. And therefore, she has persuaded us into adopting a lifestyle, not just in terms of nutrition, but in terms of practicing a cruelty-free approach to life in general and to every living creature. I think we have to recognize the autonomy and the agency of every child. Too very often, when we mainstream our policy approaches to disability, we tend to believe that we are in a parents' patria jurisdiction for young children with disabilities. Well, of course, they need robust policy making, but they also need policy making which is conversant with what they desire out of life. And I think that's something which we cannot ignore. We must also understand that disabilities, particularly disabilities originating in genes such as sickle cell anemia in our country, have a particular degree of prevalence among tribal groups, among the more marginalized citizens. And therefore, we cannot really look upon, treating these disorders as merely a function of how much of a population group are we going to improve in terms of the quality of their lives. The reason why we have to go in with policy interventions is because they represent truly specific marginalized groups in our society who are in need of care and protection. But I'd like to, before I make a more formal presentation, I'd like to only share two more examples. I can talk about my children for the rest of the day, but that's not the purpose of this conference. But I want to share with you 2 of my own associations. One of the speakers who's going to talk to you is Rahul Bajaj, who's a Rhodes Scholar. And Rahul wrote to me a couple of years ago and said that I want to come back to Delhi and intern with you. And I said, why on earth would somebody want to give up the rest of a Rhodes Scholarship and come to work with a judge of the Supreme Court? I mean, go ahead and finish your PhD. So he said, no, I have something better in mind for my future. And so he came and worked with me. But he said, before I start working with you, I interned with Justice Lalit, and I realized in that short internship that there's so much that you have to do in the Supreme Court to make that workplace a barrier-free workplace for me. So I said, well, we'll try and do that. There's so much that a judge can do with a Chief Justice can do much more because, you can change policies. But even when I was a judge of the Supreme Court at that point of time, before my assuming office as Chief Justice, that really set us into making small and incremental changes in the way we work in the Supreme Court. Digitizing files, making those files compatible with screen reader access, OCR-enabled files. The website of the Supreme Court had a visual capture. So something as simple as altering a visual capture into a verbal capture makes a difference on whether someone with visual disabilities can access all the information which the Supreme Court provides. So in the course of our association with someone who was there to learn, I think we learned so much more, and our institutions get transformed. We have Sarasuni here, and she appeared in our court a few months ago, and we realized that we had no sign language interpreting facilities in the Supreme Court. Now, how does a young lawyer who has a particular condition live with dignity and conduct her profession with dignity unless we create those conditions? And we can't look at that as a function of how much would be the budgetary impact, because it's all about the nature of the society which we wish to create in future. Do we truly aspire to have an integrated, inclusive society? And if we do, I think there is so much that our society has to do and learn in terms of the aspirations of those who suffer from conditions of disability. And the last thing, then I'll briefly make my formal presentation. Yesterday in our court, we had someone on a wheelchair, and she was really assisting the court in a very important aspect of disability rights. And after the arguments were over and she was about to leave the court, I asked her, "Ma'am, what was your experience about navigating the space of the Supreme Court before you came into the court?" So she said, "Well, I'm extremely happy because we have an accessibility desk. I was guided into where I should go. I didn't have any problem." But she says, "I have one problem, and that is your courts are so overcrowded." So I said that, there's so much that judges can do, but I don't think I can do much about the population coming into the open court. On a lighter footing, one of the problems which we encountered trying to get these children to be mobile as they were growing up was about trying to find electronically operated wheelchairs. Because if you have a wheelchair which somebody has to push along in a home or outside, that means that child is dependent on someone else. That child is dependent on someone else to go out. The child is dependent on someone else to escort her to the toilet. The child is dependent on someone else to put her from the bed to the wheelchair. We finally found wheelchairs which are electronically operated. But again, I wonder how many parents can afford this. We have a petition pending before our court on whether GST should not be removed on these assisted devices. How many parents can afford that cost of that single wheelchair? Incidentally, I always tell the girls that this is a home and not a highway. So when you zip in and around on your wheelchairs, please be careful that there are others you might be tripping over. Traditionally, caregiving has been an often overlooked and thankless task, shaped by patriarchal norms that have historically placed the burden of care squarely on families. The unique needs of persons with disabilities are still, in many cases, viewed as a private domestic issue rather than a collective social responsibility. While we may advocate for these needs to be met by our social institutions, those institutions often fall short of providing the support that is truly needed. The challenges faced by persons with disabilities extend far beyond issues of physical accessibility. They must also contend with entrenched societal biases, stereotypes, and misconceptions that permeate nearly every facet of life. These barriers are particularly pronounced when it comes to children, whose futures depend on our willingness to challenge these limitations. For children in conflict with the law, these challenges can be even more severe as they navigate a system that may not recognize their unique vulnerabilities. In the United States, studies show that as many as 70% of youth who enter the justice system have a mental health, sensory, or learning disability. I was going to spend a little bit of time on the legal framework, but I take it that, all of you who are so well versed in this area of the law are conversant with the United Nations Convention on the Rights of the Child, a cornerstone document which has been ratified by almost every country in South Asia. We, of course, have in India a robust legal framework. Apart from the Convention on the Rights of the Child, we have the international principles and guidelines on access to justice for persons with disabilities. I'm compelled to share 4 key postulates that demand our attention at the present point of time. First, recognizing the problem. How can we address a problem we barely recognize? One of the most significant challenges we face is the absence of reliable data on children with disabilities. especially those who are survivors of sexual offenses or who come in conflict with the law? How can we design policies and implement solutions without understanding the scope of the issue? The lack of real-time disaggregated data makes it difficult to fully appreciate the barriers these children encounter. Without precise data, effective planning, policy shifts and monitoring of outcomes remains out of reach. We must therefore begin by prioritizing improving the data collection systems within the juvenile justice framework. Data is the foundation for meaningful reforms, enabling policymakers to develop tailored interventions, measure their impact, and adapt strategies accordingly. Without this, children with disabilities will continue to fall through the cracks, unseen and underserved. Do we have a robust framework? Second, do we have a robust framework for facilitating access to justice for children with disabilities? The Rights of Persons with Disabilities Act 2016 is a significant step towards ensuring that children with disabilities receive the care and rights they deserve, as it provides a comprehensive framework for rehabilitation, empowerment, and inclusion of persons with disabilities in society. The Juvenile Justice Care and Protection of Children Act defines a child in need of care and protection as one who is mentally ill, mentally or physically challenged, or suffering from a terminal or incurable disease. The Act also states that anyone who commits an offense against a disabled child is liable to twice the penalty. But this punitive approach may not address the root causes of abuse or neglect, nor provide adequate support or rehabilitation for the child involved in conflict with the law. While these laws acknowledge the vulnerability of children with disability, their impact on the ground is often limited. The framework remains largely reactive, placing more emphasis on post-offense penalties rather than a proactive prevention, support, and rehabilitation. On the international front, the principles of equality, non-discrimination, and respect are foundation to disability rights. However, the lack of implementation mechanisms may render many legal protections ineffective in practice. The need to strengthen the frameworks is clear. For example, procedural accommodations such as interpreters, modified questioning, and the presence of intermediaries are often not provided, leaving children with disabilities at a disadvantage within the judicial system. Countries like New Zealand have implemented robust measures, including specialist advocates for children with disabilities and customized courtroom settings to accommodate their needs. In India, we are developing a module for vulnerable witness deposition centers. The idea of the vulnerable witness deposition centers is to have a national uniform model for devising courtrooms at low cost, consistent with our resource patterns, to allow for witnesses who are in special need and care when they encounter courtroom conflict to be able to depose effectively and without fear. The third aspect I want to emphasize is capacity building. Are we truly prepared? Are we equipped to handle the needs of children with disabilities in the justice system? A renowned psychologist, Reuven Feuerstein, posits that there are 3 prerequisites which must be met for an inclusive environment in the context of inclusive education: preparation of receiving institutions, preparation of the individual child, and preparation of parents. We need to extend this framework to the juvenile justice system. Have we prepared our justice institutions? Are the judges, police officers, and lawyers equipped to understand the unique challenges faced by children with disabilities? Sadly, the answer is often no. Professionals within the justice system require ongoing training and sensitization to comprehend the nuanced vulnerabilities of these children. Sensitization would not only reduce the re-victimization of children in legal proceedings, but also promote more compassionate handling of cases. For example, in the UK, specialized training programs for police officers and social workers dealing with children with disabilities have significantly improved justice outcomes by reducing trauma and improving communication between children and legal authorities. International cooperation is critical in this regard. Cross-border sharing of best practices, capacity building initiatives, and technical support from countries with more advanced systems can significantly improve our ability. The fourth aspect which I want to deal with is intersectionality, understanding multiple marginalizations. When we talk about juvenile justice, especially in the context of children with disabilities, we cannot ignore the concept of intersectionality. Disability often intersects with other marginalized entities, such as gender, caste, socioeconomic status, and ethnicity, amplifying the discrimination children face. The doctrine of intersectionality, coined by Kimberly Crenshaw, highlights how multiple identities intersect to create unique experiences of discrimination. For children with disabilities, these compounded vulnerabilities can have devastating effects. In a case which I had the occasion to deal with and author the judgment, Patan Jamal Wali versus State of Andhra Pradesh, the Supreme Court recognized the heightened vulnerability of a girl with a visual impairment who belonged to a scheduled caste and was subjected to sexual violence. This case not only sheds light on the sexual violence faced by disabled girls, but also highlights the double marginalization they endure, both as women and as individuals with disabilities. This dual vulnerability may mean that women with disabilities are often perceived as easy targets for sexual violence, influenced by societal perceptions of their diminished capacity and their perceived inability to speak out. Addressing these intersections is vital. We must ensure that justice system, from the police stations to the courtrooms, understands and responds to the compounded vulnerabilities of these children. The incorporation of restorative justice approaches is one such solution. The CJI Act outlines various rehabilitation and reintegration measures for children in conflict with law, such as counseling, education, vocational training, and community service. For children with disabilities, these measures can be adapted to ensure that they receive the specialized support they need to thrive. The true focus of this two-day consultation cannot therefore, and its importance cannot be overstated. I commend Justice Nagaratna for her exemplary leadership in prioritizing the protection of children with disabilities through the Juvenile Justice Committee. The consultations held across states have greatly enriched our understanding of the challenges and opportunities that these children encounter within the child protection system. Each of the sessions over the next 2 days addresses core aspects of the postulations I have flagged: recognition of the problem, building a robust framework, capacity building, and embracing intersectionality. This consultation, above all, is not just about theory. It is about actionable strategies for change. I'm also delighted with the launch of the Handbook on Persons with Disabilities, which aims to aid and sensitize not only the legal community, but also society at large in using inclusive terminology when referring to disabilities. Just recently, we dealt with a film on disability, and the film was supposed to be a film on humor about persons suffering from disabilities. Now, consistent with our commitment to the freedom of speech and expression under Article 19(1)(a), we didn't ban the film, but we laid down a cross-sectional framework on how filmmakers and producers of creative content must deal with disability. You can't exclude humor involving those who are disabled, but that humor should not target their condition by being pejorative. And therefore, this book, like its earlier, like the predecessor, the Gender Handbook which we produced, is intended to bring a greater sense of sensitivity on the part of everyone in society about the language of our discourse on disability. And of course, as you saw, the book is in Braille as well as an audiobook, ensuring that it is available to all regardless of their abilities. In conclusion, then, we must ask ourselves, are our justice systems flexible enough to accommodate the unique needs of children with disabilities? Are we building a system that seeks to rehabilitate rather than criminalize, to include rather than marginalize, and to empower rather than limit? We owe it to all children to ensure that the answers to these questions will be in the affirmative. I'm confident that this consultation will inspire meaningful dialogue, foster collaboration among all stakeholders involved, and help pave the way for a more inclusive and actionable solution-based society that we aspire to achieve in the future. Thank you very much for your patience and your time.